Welcome back, Consumer Law 101 students and scholars. My name is Aaron Swift. I'm the CEO and managing partner of Consumer Law 101 and Swift Law North. Today we are continuing our FCRA series by talking about night and day. What works for credit repair versus what works for FCRA litigation. Much like our last topic was incredibly important, so is this one. So please pay much attention and think through what we're going to talk about today because it is so important again. All right, so what we're going to talk about. Why night and day? So what does that really mean in terms of how I've labeled these differences? Then we're going to talk about the key difference and why it really is founded upon the industry standards versus legal standards that creates the natural tension between the two. Then we're going to go over examples and, like all of the videos, tied up at the end by connecting it to litigation-backed credit repair in general. Okay, so why night and day? There are so many charlatans, scammers, so-called experts, and truly even well-meaning CROs and credit repair influencers, brokers, dealership managers in the space that just know enough maybe to be dangerous or think they know more than they really do. And what happens then is, whether consumers themselves, by listening to these experts, using tools that they've bought, or even credit repair companies that again are well-meaning, they use these techniques and make wild demands on the bureaus and furnishers of information based on a lack of understanding, and that lack of understanding really leads to a lot of bravado and a lot of unhappy clients, a lot of chargebacks, a lot of fights over efficacy, and really could even open up some problems under CROA. But at the end of the day, and I stress this all the time, the Fair Credit Reporting Act is a federal law, and it requires legal analysis and legal interpretation in order to effectively apply it. So why are non-lawyers even using it, quoting it, trying to even quote case law? In fact, I'd be worried about UPL, which is the unauthorized or unlawful practice of law. But why not just partner with Swift Law North and other companies that use a litigation-backed strategy? That way you don't have to worry about these different standards. And it truly is night and day. Some things that can or should work, for credit repair just have no chance of working when it comes to litigation. So let's talk about the key difference. We've talked about in some of the videos already the standards. That's why we always go over the standards in early videos, because all of our videos build upon themselves. And if you don't understand the definitions and standards, you're not going to understand later concepts. And if you remember, one of the standards under the Fair Credit Reporting Act is that the law requires reasonable procedures to assure, quote, maximum possible accuracy. Which, if you break that down, it's an incredibly high bar. It's the maximum possible accuracy, which in one way you could think should be 100% accuracy. Even when you're dealing with billions of bits of information, maximum possible should be as close, if not near perfect. But there's a tension between that standard and the injury and fact standard that we've talked about for standing purposes. So something that can or should or might work under credit repair because something is technically wrong, that just may not be enough to sue under because there's no real injury. So far too often I hear these experts, Metro to this, Metro to that, or I've read the CDIA manuals or the Fannie Freddie guidelines, and I know this, and the credit reporting agencies or furnishers, they have to delete or else. It's just really not the same. And selling false promises, making false guarantees on a misinterpretation of the law, misinterpretation of the standards, is really dangerous, and it hurts consumers and puts them in the worst position. And the last thing we should be doing on this side of the equation, on this side of the good guys, V in these lawsuits, when we're suing these defendants, we want to do things right. And playing gotcha games, trying to read into a technical issue, and then suing under is just not going to work. It's going to upset the judiciary. It's going to bring on some regulatory heat, and it's a big problem. All right, so let's talk about some examples. What does it mean that something can be technically wrong, or it could work for credit repair but not work for a lawsuit? This is the classic example. You have a client who was repeatedly late on accounts or multiple accounts at different times. This person was robbing Peter to pay Paul. He or she make payments on this account this one month and this account on that month, which led to a lot of derogatory reporting. So let's just say at one point this person was 30, 60, 90, 120, 150, 180, and the account was charged off for a very long time. Let's say the consumer can show that the very first 30-day late is off by a month. It's a month early or a month later. Yeah, that's just not going to really be enough for a lawsuit. Even though the Metro 2 guideline is going to say, hey, if there's something wrong, you have to delete it or you must modify. And that is true. But if you try to sue a furnisher and say, there are these 30 other derogatory remarks, you got one tiny issue off by 1 month, you're going to get laughed out of court. That's an example of something that should work for credit repair. If you send a letter demanding that 30 get fixed, it should work, and maybe it will. But if it doesn't, it's not going to lead to a lawsuit, certainly not from any plaintiff's lawyer who really understands how these cases work. Another one that's classic is, there's no data in payment history grids. You see a lot of OKs, you see a lot of X's or dashes or these NDs. It's wrong. It's incomplete. A lot of these companies can certainly go back in their payment records and show that payments were received during those months. But usually that's just not enough. If it's an otherwise positive account, how much of it is it hurting? I've seen people try to sue over no data when it would be negative behind there. That the data that should be there was negative. Heaven forbid. That's not going to be an injury caused by that reporting. Another one, and this one is huge. This is so misunderstood by even lawyers because they're, plaintiffs' lawyers and my colleagues are losing these cases across the country. We all see this. You have a trade line account, a collections account, and it says C or CO for 15 straight months. And, that's a charge-off designation. On its face, that seems wrong, right? Like something can or should only be charged off once or maybe twice, depending on the specific types of charge-offs. And again, go back and watch our video on charge-offs. Again, most cases there's one charge off, it's static, and then it can't happen again. But courts just don't care. On one hand, they're saying, yeah, but the status is that it remained charge off. So that's why it is okay to put C or CO in all those months successively. Or that's just one reason or one derogatory remark among so many that it's not enough. It's not material enough. And then lastly, this is very important. Remember, go back to the defenses to these cases, and standing and damages is so important. You could have incredibly significant errors. Someone's reporting a $50,000 loan against someone that they don't owe. If that credit report was never published, and by published that went to someone, no one requested it, there was no credit application, and we have clients that are just children of the Great Depression or children of the Great Depression. They don't like debt. They paid cash their whole lives. And they don't do any, credit shopping. So I have a victim of identity theft, a case where all the information on her credit report just never went anywhere. She was upset because she could see it, but she never once applied for credit. There wasn't even a single account review inquiry. And at least here in the 11th Circuit, that's not going to be a case. So that would be something that, if you dispute for that woman, it should be fixed. Absolutely it should. If you can really show, accounts were open up for identity theft, but that may be good enough for credit repair, but not enough to sue over, because in that case, at least the 11th Circuit and many others would say that lady hasn't been damaged yet, not in a really enough way, because no one has seen it. This hasn't led to a denial. It hasn't led to emotional distress because other people are seeing it. And go back to, to the invasion of privacy. How has her reputation been harmed? How has her privacy been, invaded if it hasn't gone anywhere? So those are just a lot of examples. How does this connect to credit repair? This is really kind of the whole kit and caboodle. This topic itself is kind of the main sales pitch for why litigation-backed credit repair is really the future. It's the best and only repair toolkit to use. These other so-called experts who will sound fancy, they're going to sound knowledgeable, they're going to quote Metro 2, EOSC, or CDIA just to sound, and it may be well-meaning, and they may know a lot, but they just have no idea how, if at all, to then really navigate the waters of applying the tension of the standard's maximum possible accuracy versus injury in fact. And just to navigate those waters, one, I think you should be a lawyer. These are all laws. But secondly, you have to have the foundational knowledge to use these statutes as affirmative leverage. We don't want to just be on our heels defending, playing goalie against a bunch of collectors and credit reporting agencies. The whole point of this is litigation-backed strategies are so powerful. By using them in a defensive or, most importantly, an offensive way, by suing these companies, again, we're going to get more deletions, more debt forgiveness, more debt waivers. And at the end of the day, happier clients, less chargebacks, more money for you and for us. So, thank you again for tuning in. This has been an incredibly important topic, really going over the differences between what can work for credit repair and what can work for FCRA litigation. For more information, watch our videos, visit consumerlaw101.com and swiftlawnorth.com. Thank you.